I think most judges would agree that judicial independence is crucial. Do you agree? What do you think?
Oh, yeah. I mean, it's central. The only real political science innovation in our Constitution, I mean, you know, parliaments have been around for 800 years, and obviously executives, is the establishment of an independent judiciary. Even places you think are similar to ours, like England, the judiciary in England was part of Parliament. I mean, they sat in the House of Lords, and because Parliament was supreme. But in our Constitution, judges and the judiciary is a co-equal branch of government, separate from the others, with the authority to interpret the Constitution as law, and strike down, obviously, acts of Congress or acts of the president. And that innovation doesn't work if it's not, the judiciary is not independent. Its job is to obviously decide cases, but in the course of that, check the excesses of Congress or of the executive, and that does require a degree of independence.
What do you think of these calls for impeachment of judges based on the decisions that they've made?
Well, I've already spoken to that, and
Yeah.
you know, impeachment is not how you register disagreement with decisions.
That's what you're for, right? That's what you're there for.
That's what we're there for.
Yeah. So lots of decisions that you make interpreting the Constitution have real life practical consequences. So just as a for example, the Second Amendment decisions result in more people having guns. And the Obamacare decision resulted in more people having health insurance. Obergefell resulted in more same-sex marriages. Do you think about those practical consequences when you're interpreting the Constitution? And should justices think about those practical consequences when they're interpreting the words of the Constitution?
Mainly no to both of those questions. Because if you do that, you know, with one exception I'll talk about later, but if you do that, you're kind of putting yourself in the place of the legislator. You can say, for example, a consequence of the Second Amendment decisions are, well, more people have guns, and so there's more, you know, accidental shootings, more shootings. Or you can say the consequence is that more people are armed, and therefore they're in a better position if there's foreign invasion, as there was with the British shortly after the adoption of the Second Amendment, so that's a good thing. Now, if you decide one of those or the other based on your view of what you think is best, you would be substituting your own view for that of the people who wrote the Constitution. So, no, I don't think that's not a big part of at least how I do my job, sort of what a purposivist approach is what people would call that, because I think you're making yourself the arbiter of what people were trying to accomplish in that law, when you really need to be doing is sitting down and reading it, you know, in its appropriate context and trying to figure out what they meant.
Yeah.
Now, at one extreme, if an interpretation you adopt leads to some absurd result that nobody could plausibly have intended, then yeah, then the consequences make a difference. But I think it's more important to figure out what the people who wrote the law had in mind and what they meant by the words they used, rather than think, you know, what is this type of legislation for? Yeah. Because then the interpretation flip-flops.
Yeah. So the courthouse here in Buffalo is named for Robert Jackson, and you clerked for Justice Rehnquist.
Right.
Justice Rehnquist clerked for Justice Jackson, so you're sort of his grandson.
Sort of.
In a way. Yeah. Does that have any special meaning for you? I mean, I know one of the photos, one of the portraits you have hanging, one of the 4 portraits you have hanging in the Justice's conference room. In the conference room. Yeah. Is Jackson. Yeah. Would you talk about that a little bit?
Well, sure. I mean, obviously one of the more remarkable members of the court in our history. Part of the reason he's in our conference room is he was the Solicitor General who argued before the court, the Attorney General, in charge of the branch of justice and the administration, the prosecutor at Nuremberg, which was very controversial on the court. His colleagues did not think that was necessarily something he should be doing. And obviously one of the great justices. I mean, his eloquence is really extraordinary. His eloquence at Nuremberg was extraordinary. So, yeah, I think it's a great grandfather to have. Now, the other portraits, John Marshall Harlan is there. And I just think somebody whose parents name him John Marshall, who then lives up to it and ends up on the Supreme Court, deserves
Incredible.
A painting. And seriously, all his pronouncements in a number of areas of the law, I think, are really remarkable.
He was a dissenter in Plessy, wasn't he?
Yes, alone. That's when he said that we have a colorblind constitution. And the other one is Cardozo. At one time, I had 5 colleagues on the court from New York. So I figured I had to give them some New Yorker on the wall. And then, of course, the great Chief John Marshall as well.
Yeah. So I read a speech that you gave to your son's graduating class that talked about the importance of getting to know the folks who work at the school, the custodial staff, the janitorial staff, those kinds of things. Why is that important, and why was it important enough for you to give that message to your son and his classmates?
Well, it was 8th grade, and it's a time when they need to learn a lot of things. I mean, it's important, just it's basic courtesy, but also it's important to appreciate that no matter high and mighty you might think you are, or others might, that there are other people that are doing things that are just as vital to the functioning of our world and as anybody else. And all the people who work at the Supreme Court are part of the process that ends up in our articulation of what the law is. And whether it's the Chief Justice or somebody in the print shop or one of the law clerks or anybody else. And I think if you lose sight of that, that's a real shame. And I do think, again, particularly 8th grade is a good place to learn that.
Did you do that when you were in school? Did you get to know those folks when you were in?
Oh, sure, yeah. But in 8th grade, I mean, those people were the boss.
Yeah. That's exactly right. Yeah. That's exactly right. Sometimes I'll have folks who cleaning the office will come in and apologize to me for coming in and cleaning the office. And I said, if you folks don't do this, I can't do my job. So, it's as you say, it's all.
Yeah, I apologize for making such a mess, which I usually do.
So you talked about a few minutes ago reading petitions for certiorari and briefs. What's the sort of criteria that you use for deciding whether you want to take a case? What jump, other than writing about red dogs, what jumps out at you?
Well, and it's pretty clear that it doesn't really matter how right or wrong it is. I mean, the one thing you can say in a cert petition that's not a good idea is how horribly wrong this is, because the first message that comes across to us is that, well, if it's that wrong, we don't have to worry about it. Nobody's going to follow it. A mistake's been made, but one thing that's certain, it's not our job. We're not a court of error in the sense that we correct mistakes. So what we're looking for are conflicting decisions on the same law that have to be fixed. I mean, if one person reads this law and says you can't do this, and the other person says, no, it means you can't do this, it should mean the same thing across the country. And so that's more the type of case we would take to resolve that disagreement. So people who want to get their cases heard need to have somebody who's good at explaining why we need a greater degree of uniformity. You can't say in New York some particular expense is tax deductible, but in California it's not. So a lot of the cases we get are actually not that glamorous. They're not that interesting because there are a lot of areas of federal law like patent law and copyright law, tax law, all sorts of things. And when those disagreements come up, we're the only ones who can fix it. So a lot of our docket is pretty mundane.
Is there something too, though, putting something in the cert petition that'll catch the judge's eye, like the red dog story? I mean, do you find yourself, when you read something like that has something that catches your eye, drawn to it a little more?
Oh, sure, yeah. I mean, we take whatever it is. I don't know what the number is, 1.5% of all the cert petitions. You've got to do something to stand out of the crowd, unless you have a really good case. That may be enough to get our attention, but other than that, it makes sense. You have to be a good writer. If you're there, I mean, obviously our law clerks read somewhere all the petitions and they write summaries, but we read from those summaries ones that we think might be likely candidates, and it's very hard to pick out the right ones.
Some of your colleagues have written autobiographies. Have you started yours yet?
No.
Are you gonna?
No.
You won't. Why? Why not?
I think my life is very interesting to me. I'm not sure it's terribly interesting to anyone else. And now that's not true of some of my colleagues. Justice Thomas's autobiography is absolutely gripping. If you haven't read it and are at all interested in the court, you should. It's such an extraordinary story. I really couldn't put it down. But I don't think I have that in me.
Let's talk about your role in terms of you as a public figure. Obviously, you're very recognizable. People know who you are. You have to be on all the time, like now. How do you separate that from your private life? How do you keep some privacy in your life and have this kind of bigger than life role as Chief Justice of the United States?
Well, recognizable. My wife and I were on vacation in Portugal last year, and another American sort of came up to us, and he's looking at me and says, "I know you. I know who you are. You're John Boehner." And so, they were sitting next. I had to spend the whole evening pretending to be John Boehner. And so, when you say readily recognizable, really not, to be honest with you. It's getting worse, though, in general, just because the work of the court is getting a higher degree of publicity. So it is a problem. I will say 99% of the interactions I've had with people, they come up and say hello, which is fine. And so that's good. But we're not as recognizable as you might think. Among a crowd of judges and lawyers, yeah, but in the public at large, not much of a problem.
So some of your colleagues have retired. You ever think about that? I mean, you're too young now, but someday, would you?
No.
No, because you love what you do too much.
I'm going out feet first. Mm-hmm. It's just.
I am too.
Yeah, good. Well. No, I say that now. I mean, I'm sure if your health declines and all, and if you recognize that you're a burden to the court rather than part of an assist to everybody, then it'll be time to go. I have very good friends that were for a long time, many years, and I've sat down with them and said I want at the appropriate time, because you don't always notice that you're slipping. I want the two of you to tell me if it's time to go. It's a long pause, and at once the two of them said, "It's time to go." So I said, "All right, never mind. I'll find something."
I have that deal with Chief Judge Wolford.
It is kind of surprising.
She's going to tell me. She hasn't said anything yet. Maybe after this she will.
It is surprising how rare it has been on the court for that to become an issue. Really just a handful of times. I think it's because it's a collegial, both in a technical sense and in a popular sense, group of people that you develop relationships where if the people do come, there have been times when somebody has stayed a little longer than they should, then the other colleagues come, and it's always really worked out. So I don't think that's going to be a problem. So, but it is, I still feel pretty healthy.
Yeah. Do you love what you do? I mean, do you really look
I do.
forward
It's
to going to
exciting
work?
to get up, every morning and go into work.
Doesn't seem like work when it's like that, right?
Some days. Some days it does. But it's nice that we have a break in the summer. Louis Brandeis, one of our great justices, said that he could do the 12 months worth of work in 10 months, but he couldn't do it in 12 months. And I think there's a lot of wisdom in that. We work at very close quarters on very important issues, on very sensitive issues, at work that is hard to do, and we do need a little break from each other.
Yeah.
But it's interesting. It really creates such a strong bond. I'm sure people, listening to the news or reading our decisions, particularly, decisions that come out in May and June maybe, think, boy, those people really must, hate each other. They must be at hammer and tong the whole time. And we don't. I mean, the dealing with the type of cases we do and their significance, it's something only those 9 people can know. Whether you take something as basic and fundamental as whether somebody lives or dies, you share that in a very intimate way, or whatever else that is the most important issue facing the public. And even if you are on opposite sides, more often than not, and we're not, more of our decisions are unanimous than anything else, people lose sight of. But it is a strong bond.
I think when Justice Ginsburg and Justice Scalia were on the court together and their friendship got some publicity, I think people got to understand that a little bit more, because RBG talked publicly about it a lot, and just how fond she was of Justice Scalia and vice versa, even though they were at opposite ends of lots of decisions.
Yeah, and a lot goes into that. And you have more in common with some colleagues than others.
Sure.
So I do things with some of my colleagues that I don't with the other, and vice versa. But it is a bond, and there are issues and discussions I don't share with my wife, and I know others don't, just because they find it easier not to know, in terms of that, so they don't have to worry about it. But so it is it's a small group. The bonds of real affection and friendship and shared experience are very, very strong. And I think we try very hard not to let disagreements of the moment break that.
So you've been on the court for 20 years?
Yeah.
And you were a circuit judge for a couple of years before that.
Mm-hmm.
Read a lot of district court decisions over the years. Mm-hmm. So I'm looking for a little advice now. What can you tell district judges about the decisions they write that might help us?
Yeah. Brevity is good. And I think it's
Are my law clerks listening to this?
Particularly with the district court, we recognize the primary responsibility of the district courts to deal with the facts, and we don't want to be second-guessing the facts. And so that's an important thing to address if it's going to be in the opinion, to make it clear what findings you've made about what and what hasn't. And then I remember Justice Rehnquist, for whom I clerked, was very adamant about that, and he was a very good trial lawyer. He said, you don't want to waste too much time, on the law. The facts are more important than the law, and then, as it moves up, people are focused more on the facts. He tried, and when he was in my position as Chief Justice, he was remembering his days fondly as a trial lawyer, and he assigned himself to a district court in Virginia to hear a trial, just to kind of get back on the saddle in that way and stuff. And he did, and he issued a decision, and they appealed, and the Fourth Circuit reversed him.
Is that right? And he never did it again.
No, but the only thing that made him mad, and he was really upset about it, is that they issued it as a per curiam opinion. Said nobody had the guts to put their name on it. But,
You ever think about doing that, trying to be a trial judge? No. Because, well, you didn't try cases, so
No.
difference there. Yeah. So you became Chief Justice in 2005. You worked with Justice O'Connor and then Justice Ginsburg.
Yeah.
And now there are more women on the court than ever. Has that changed the dynamic or the culture of the court in any way?
No, to be my honest answer, I don't think it has. I'm sure when Justice O'Connor came on as the first woman,
Right.
it had all sorts of consequences and changes. And but now, to be honest, I don't think, in terms of the dynamic at conference or the discussions and all that, I just don't think it makes a difference. I wouldn't say that our conferences or our discussions are different because. I would say it's different because those particular individuals are there and they all come and bring different perspectives and all, but I don't think I would say it's different than because they're women.
Mm-hmm. So there's been a lot of criticism of some decisions because they've changed precedent, right? The abortion decision most recently and other decisions like that. But that happens all the time, right? I mean, there's lots of times when courts have precedent that they think needs to be changed for whatever reason. What kind of criteria do you apply to that yourself?
Well, first of all, there's a lot of misconception on that subject. See if I make sure I get these numbers right. The recent study, the Warren Court overruled, I think, 3.2 decisions on average, a year. Mm-hmm. The Berger Court actually had a little bit more. I think they did 3.6% a year. The Rehnquist Court moved down a little bit, only 2.4 cases, not percent, cases a year. And in the past 20 years, the number's been 1.6. So people have a somewhat wrong view of how many cases are being overturned. Now, we take fewer cases now than they did before, but the number of important ones that would be subject to overruling are the same. So a lot of people talk as if we're overruling a lot more. It's the lowest it's been since the 50s. And some cases should be. I mean, aren't you glad that, Brown versus Board of Education overruled Plessy, or that Katz overruled Olmsted? So the idea that it's invariably a bad thing to overrule precedent is I think, quite mistaken. At the same time, you can't do it willy-nilly. Just because, you look at a case and you think, gosh, I would have had that principle come out the other way, that doesn't mean you overturn it. Stare decisis is an important part of our work. The law is supposed to be predictable, so you need a special justification before you want to overrule a case, other than that you just happen to think it's wrong.
We were talking about the Barnett case a little while ago, and that was a case that overruled a decision that Justice Frankfurter made just a few years before.
Gobitis or Gobitis, whatever.
Yeah. And so, it's been around for a long time.
Yeah. So when you do that, the first thing has to be that it's clearly wrong. The second thing has to be, does that make a difference? I mean, if, for example, you say, you can't figure out what the filing deadline is, is it 10 days under the rule or is it 12 days? You have to decide it. But you shouldn't come back and say, it should have been 12 days, not 10 days, so we're going to overrule that. I mean, that's something that many cases, it's more important that they be decided than that they be decided right. Mm-hmm. Whether it's 10 or 12 days is a case like that. So it has to be a case where it really makes an important ongoing difference and be significant enough to the legal system that it's justified to overturn the approach. But it's not something you want to do very often.
Can you talk a little bit about your experience clerking for Judge Friendly and Justice Rehnquist?
Yeah, two wonderful years in my life, and two totally different experiences. And I have to say, at a very personal level, the chance to clerk with Judge Friendly was very important. I graduated from law school in 1979, and this may be just the way I looked at it, but maybe it was because I, being a kind of lawyer was a second choice for me in general. But the law was a very cynical enterprise back then, I think. And in some ways it's good and others bad. It was very instrumental. People were using law as kind of a vehicle to achieve a particular objective. There's nothing wrong with that at all. That's a lot of people, do that, but also in a cynical way. And law was not regarded as something of sort of moral value, for want of another word. And so I felt, frankly, that maybe this had not been a good choice. This wasn't something that was uplifting. If you had a particular agenda you wanted to pursue, good, it could help you do that. But then I went and, was at the elbow of this extraordinarily great man, one of the most remarkable judges, and he saw it differently. He really looked at it as a valuable gift that we had inherited for ordering society in a reasonable way. And he was somebody who was totally apolitical. The most brilliant judge of his generation. Richard Nixon didn't appoint him to the Supreme Court because he thought he would be soft on crime. And he would have been, from Nixon's perspective. He would have applied the law as it should be, and it meant some criminals were going to go free and others weren't. And he was able to sort of construct, certainly in his opinions, which lawyers here know were remarkable, realized that this was a system that had internal coherence and that was really a gift, and it needed people who are willing to view it in those terms rather than this is how I'm going to use it to get to a particular result. So that was where kind of I left my cynicism about the work that we as lawyers and judges do, and appreciated that it had a greater worth. And just in terms of writing, he was a remarkable, gifted writer. He would come off of the bench after argument and sit down with a legal pad, two of them, one for text, one for footnotes or notes, and just start writing and finish it in 1 day or 2 days. And the secretary would type it up and give it to one of his law clerks, and we'd look at it and say, well, what does he want us to do? And he would have some ideas and look at it. So that was a really remarkable year. And then with Rehnquist, Rehnquist was the generation between. Judge Friendly was kind of like almost like two generations. He was older, and I was just out of law school, and Rehnquist was kind of right in the middle. A different approach. His writing is crystal clear, very direct, and had the same sort of appreciation and, I don't mean to overuse these sorts of words, but reverence for what the law does, but was very, direct and analytic, and you sort of knew exactly how it was structured and where it was going. So it was a nice experience for me to have two very different people, and they really admired each other. In fact, I got the clerkship with Rehnquist because he and Friendly were at a conference together, and I think Justice Rehnquist asked Judge Friendly if he had any good law clerks, and he mentioned one, and I guess somebody else hired that one, and then he mentioned anyway, I don't mean to be long-winded about it, but you do kind of look back at that and see these sort of formative influences in your life, and are grateful for them.
Does the way you deal with your clerks, by and large, mirror the way they dealt with you?
No, I wouldn't say that. When you're in the middle of it, it's kind of hard to be self-conscious and appreciate. I mean, the one thing I do know is that the four clerks really do form quite a common bond. And Rehnquist used to talk to us about how that was, and he said it's because the clerks are united by a common enemy. I really, it's kind of hard when you're in the middle of it to see how, they might view the experience.
How do you work with your clerks? How do you?
It really varies from case to case, Sometimes if the facts are a little complicated, I'll want them to take a look at the record more than they might otherwise. Sometimes if I feel comfortable that I know the law in an area, I'll have them do that, but I would go in much more carefully because I'm probably wrong about it. I want to make sure that I'm not letting, errors that might have crept in affect my understanding. And then we'll go back and forth. Sometimes I'll draft something and they'll look at it, and they don't have the problem I had with Judge Friendly. Their edits come back pretty extensive sometimes.
And you encourage that, right? I mean, I'm sure you ask them.
Well, what's the point otherwise, right?
Right, exactly.
And sometimes I'll want to look at the facts a little bit more. But then when we get closer to the end, I have all four of them sit down together and we all go over the draft of the opinion. So you have somebody who's sort of been looking at it very carefully. Hopefully I'm one of those people too. And then the others who have just kind of like read it. So in a way, it's like, when I talked about doing briefs, you want to make sure that someone sort of putting eyes on it for the first time can really figure out what it says.
How do you decide which clerk works on which case?
I leave that entirely up to them.
They make those decisions?
Yeah.
You always happy with the decisions they make?
No.
Well, you still don't put your thumb on the scale?
To be honest, they're all extremely bright. It's a real, as I'm sure you know, it's a real gift that the system has developed where we get these very, very bright people to work very, very hard, and they come up with such great work products. So.
And when you hire clerks, have they generally clerked for a district judge or a circuit judge first?
Oh, sure.
Always?
Always, yeah.
So unlike Justice White, who...
That was kind of the fading out of that experience, I think. And, you want to get the view of a judge who's been with them for a year, I think, because that helps a lot.
In one-year clerkships?
Absolutely.
Why?
You don't want them to get too good. I mean, that's the case. No, very seriously. I mean, you don't want them to get too good at what you're supposed to do. You want to make sure that you are the one doing the work. Yes, they're going to help you on what the cases say about this or how the facts look on this issue, but you don't want them to get too good because...
And because you think there's a danger of you using them as a crutch too much?
Yeah, you want to make sure that issue doesn't really come up.
Yeah.
And also it's a real valuable thing for me, and I know other justices, to have these sorts of, to be a little more attuned to what's going on in the law schools, and having a fresh batch every year. You learn more about what the teachers are teaching and what the students are interested in, and then they go out. So I have now people that clerked for me 20 years ago. They're in the midst of their professional career, leaders in the bar or leaders in academia or leaders in business, and they're real listening boards. We have a reunion every year. It's coming up in a couple of weeks. Hopefully we'll have a good turnout. We usually do, and you learn from them all that's going on. What's going on in the law firms, and the people who are there will let you know. What are they teaching in law schools these days? And they'll let you know. What are you teaching in law schools these days? And it's nice to have that pipeline. I mean, now I have almost 100 out there at different stages, and it keeps you attuned to what's going on.
Yeah, I mentioned to you earlier today that I have you to thank, you and Dave Lebron, who is the president of the review, to thank for my clerkship. You sent me to, or suggested that I apply to Judge Irving Goldberg down in Dallas, Texas, and that was the best professional year of my life because, as I said to you earlier today, it was a wonderful experience kind of being a judge but not having the buck stop with you. So the pressure's not there, but the wonderful part of the job is. And that makes clerking, I think, a really unique experience. So let's get to our time is running out. Let's get to the heart of what I want to talk to you about. There's a lot of Buffalo Bills fans here today.
Yeah, listen.
And when the playoffs come around, there's a lot of calls that go against us. Are you going to be around to handle some emergency appeals this season? You know, we're getting tired of the same old thing happening to us year after year.
Yeah,
after year.
I can see that. Yeah.
Yeah.
Well, I was here long enough. I know I had a poster in my room of Jack Kemp, quarterback, and I think Darryl LaMonica was there too.
Yep.
And Pete Gogolak, who was the first soccer-style kicker. Even Cookie Gilchrist, if I'm remembering that. So that was what was posted on my wall. But I left when I was 10, and we moved to a town in Indiana. Chicago was the closest place. So
you're a Bears fan?
I'm a Bears fan. But look, when I was growing up, it was Dick Butkus, Mike Ditka, and really, if he hadn't blown out his knee, the greatest running back in NFL history, which is Gale Sayers. And we were near. They had different connections with. They would come and talk at the grade school even, and because we were in Indiana, but on the lake, and people liked to go there. And it was just.
Yeah, I say Gale Sayers, I think, was the most beautiful runner I've ever seen. He just was so graceful and so much fun to watch. And it was a shame that he blew out his knee. Yeah,
I have a signed helmet of his. Not of his. It's a Bears helmet that he signed in my chambers.
Very cool.
Yeah.
Well, thank you so much for doing this. This is an honor for me, and this was a very pleasurable hour. So.
Well, not at all. Thank you for having me, giving me the opportunity to go back and see my boyhood home, and rekindle memories of Buffalo. I appreciate it.
We're proud that you're
Thank you all
here.
for being
Proud
here.
that you're from here.
Thanks, Fred. Great.